Diddy could be a free man very soon for two reasons. One, the sentence he got was way out of whack. And two, what he did was not violate this Mann Act. He was doing amateur porn. Welcome to the Two Angry Men podcast. Mark, I think Diddy has a reasonable chance of getting out of jail, getting out of prison soon as a federal district appeals court hands down a ruling based on oral arguments that they heard this week. It sounds to me like they may be buying at least one of the defense's arguments, and that has to do with his sentence.
Right. And I listened to it yesterday. And for those who haven't, we've done some clips. If you like to hear really smart judges and incredibly good and prepared oral advocates, for a legal nerd like me, this is just nirvana. I mean, I think Branson's got a couple of these clips, doesn't he?
We do. Let me just kind of set this up. Diddy was sentenced to 50 months in federal prison. He was convicted on 2 counts of the Mann Act. He was acquitted on racketeering and sex trafficking. So what the defense argued is when you look at Mann Act convictions, the average sentence is 15 months, and Diddy got 50. And what they're saying is the judge was considering all of the conduct that was related to the charges for which he was acquitted, sex trafficking and racketeering. He was considering force and coercion in the Cassie video. And the defense is saying all of those things were the evidence where the jury ultimately said not guilty. So you can't consider that in the Mann Act, which is simply taking prostitutes across state lines, correct?
Correct. And on top of it, as one of the judges said, I forget who it was, either Nardini or Baker yesterday, there has never been a Mann Act sentence in the history of the United States that was 50 months. So you said that 15 is what the norm is.
And he has served 19, which means that if
Actual.
So if the court buys this, he's free man. So there are 3 judges on this appellate court. And I think there's going to be a split decision here. But we're going to play you the first one where the defense lawyer is arguing that all of this evidence, coercion and violence and Cassie video, that it should not have been considered, but the judge considered it. So here's the way this went down.
I think what Judge Subramanian did here is he looked at the entire record, all 8 weeks, and imagine that being like a pizza, right? He's thinking about the entire trial as a pizza, all the facts, all the evidence adduced during that 8 weeks. But in considering the guidelines, he's not considering that whole pizza pie. He's considering a slice. And what's in that slice, it's what tends to prove the Mann Act. And that's why when he looks at the 2 specific incidents of coercion, those incidents are specifically tied to transportation. They're tied to the Mann Act.
And I guess that's where I'm suggesting that I don't know how to follow the pizza metaphor, so I won't try.
For those who don't know, that was Christy Slavic. Christy Slavic was both a member of the trial team, although to some degree in the media overshadowed by Maureen Comey, overshadowed in terms of the publicity around it.
We should make it clear, this is the prosecutor.
Correct. It's the U.S. attorney who, in the federal system, oftentimes they will argue their own cases. That's what she's doing here. The judge who was speaking to her, who was savagely saying, I don't follow the pizza analogy, was Judge Nardini, and he was an equal opportunity, I don't want to say curmudgeon, I would say hard on both sides. And what she was trying to say, her argument is, look, the judge was considering everything that he heard, and And that I don't think, as Judge Nardini says, the pizza analogy does not work.
See, this just okay. I'm going to try to use this pizza analogy. That if you say that one slice of pizza is the Mann Act and all the other stuff was racketeering and sex trafficking, then the judge should only consider the evidence in the one slice. But what I'm confused about is she's saying that, as a prosecutor, she's saying, no, we're allowed to consider the whole pizza when we're looking at the Mann Act. But by talking about the slice, it seems like she's talking against her own argument. What am I missing here?
You're not. In fact, you've completely crystallized the problem, because the problem, the smart aleck in me would have said, if you're there, no, Judge, or Your Honor, the district court judge ate the whole pizza. And the problem is, and this is what one of the judges pointed out, I'm going to hold you, Miss Slavic, to what the prosecutors, and it wasn't her, it was Maureen Comey, argued in the closing. In the closing, they even characterized it. They said the Mann Act was a sideshow. They had the record in front of them. It was actually an incredible oral argument, in the sense it was the only case on calendar, which is unusual in most cases. You had three judges who obviously knew the record, and they specifically were asking and showing quotes to the prosecutor. This is what you said in closing. Why are you telling the jury one thing, losing your case on the main counts, which are the RICO and the sex trafficking, and then telling us, clean up our mess because we didn't really focus on the Mann Act and the jurors convicted, but don't bother us with what we said at the time, was in essence what the judge, at least Judge Baker, was asking.
I don't think that's right. I think what the judge is saying is, yeah, you submitted charts in the Mann Act, but really that's all you have to do is show that you transported a prostitute from one state to another, and you don't need to deal with violence. It has nothing to do with violence or coercion or anything like that. That in a way, the judge is saying the charts are enough, but that's the only thing that's relevant to the Mann Act. That was the way I understood it. And that slice of pizza does not include the Cassie video or any of the allegations that he forced any of these women into freak-offs. That is what I understood this judge to say.
Well, the problem with that, and mind you, if you're handicapping this, and by the way, it's very difficult to do. As somebody who's followed the law intensely, and you're a lawyer, Harvey, and for those who are non-lawyers, when you try to understand somebody's Socratic style who is a judge, they oftentimes will ask you hard questions, and they will ask both sides hard questions. And there's a thing called a hot bench when the bench is actively engaged. I wouldn't call this a hot bench, although Judge Nardini at times was a little hot. But I would say that the problem was, the argument was that you had Judge Subramanian, who was the trial judge, saying that all of these things that he was using as acquitted conduct. But then he did a kind of a safety valve. And Christy Slavic did a nice job, I thought, of saying it. He tried, and she called it out. She actually said he wasn't just insulating himself. That's what I was thinking. I was thinking a smart district court judge says, well, even if I was not considering the acquitted conduct, what he was not found guilty for, I would still give him 50 months, meaning I had an independent basis upon which to do it. That is, I think, what this court is focused on, because a number of times, two of the three judges said, there is no case on the sentencing guidelines, none, no federal precedent at all on what rule the district court is supposed to use. Give us a rule. They asked that of Alexandra Shapiro. They asked that of Christy Slavic. I think, if I'm going to prognosticate, that the only way they get all three of these judges together is they say, we're going to write the rule. We're going to have a rule that says you can't consider acquitted conduct in a trial where elements the prosecution didn't prove, and we're going to hold the prosecution to what they told the jury. You're going to be judicially stopped from taking one position in front of the jury and another position later in front of the judge. And we're going to say, Judge Subramanian, resentence him.
Okay, so we're going to play one other clip, and it goes to this. And again, so everybody understands, the issue is, should this trial judge have considered evidence that was presented in the sex trafficking and racketeering charges, namely violence, force, and coercion, in sentencing him to the Mann Act? This is another part of this hearing this week.
Judge Subramanian properly considered the aggravated manner in which the defendant carried out his Mann Act offenses, which is, of course, consistent.
You say aggravated manner. Let's talk about that. Why shouldn't we hold you to the way you prosecuted the case? You went to the jury and you said, this man did all these terrible things for purposes of the RICO conspiracy, for purposes of sex trafficking, and they acquitted him. And then on the Mann Act, it was just a sideshow, and you put in, I don't think there was any evidence or any live witness testimony. Just look at this, you said, look at these charts. And now you want us to rely on all this acquitted conduct that was presented to the jury that was presumably rejected for purposes of, or to allow a district court for purposes of the guidelines calculation. So why shouldn't we hold you to what you argued to the jury?
That judge is squarely on the side of the defense there, saying the same thing we just mentioned, that, hey, you presented all that other evidence and you lost. The jury found him not guilty. So why should we not hold you to the standard? You lost, you can't use it. And yet the judge seemed to use it. And it sounds to me like this judge does not buy 50 months as an appropriate sentence.
I've been saying, and obviously I'm very close to this, so in the comments section, be more original in your comments. The fact is that if you're Puffy or you're an accused and the government comes after you, understand that you go to trial and you are risking the rest of your life in prison and all of your assets. That's what happens if you get nailed on the RICO. And the sex trafficking is maybe not the rest of your life, but for practical purposes. So take that. And if you go and the government gives it their best shot, which they did here, they put the best and their brightest on it, and they left no stone unturned, and you lose, then why do you get to under what principle of fundamental fairness? Because I will tell you, there is a principle called equitable or judicial estoppel. You can't say one thing to a court and then another thing to a court, take two diametrically opposed positions and have the court just be this kind of schizophrenic receptacle. So why,
it's not schizophrenic, it's inappropriate. In other words, what the defense was arguing is that it's just unfair. It's wrong to take elements of a crime for which somebody is acquitted and apply those elements to something they were convicted of that really is not an element of that crime. I think that's what they're saying.
Well, yes, but the schizophrenia is they're saying it's not acquitted conduct. I mean, there were portions where Christie was arguing, look, the judge said, I'm not considering that. Right after, and bless his heart, Judge Subramanian is talking about everything he saw. So he ate the whole pizza, and this idea that somehow he's going to just serve one slice, which is the Mann Act, after he talks about how much indigestion he's got from eating the whole pizza, I think is fundamentally intellectually bankrupt. And that's the problem with this. How do you consider this against the backdrop? Number one, the federal criminal prosecution, I think they win 98.9% of the time. That's what they win. And out of that remaining 1% that go to trial, it's also a slaughterhouse. There are lawyers who are walking around who practice their entire careers and have never heard the word not guilty in federal court as a defense lawyer. And I will tell you, I've known prosecutors who never lost as a prosecutor and never won as a defense lawyer. It's that rigged. So if you've got that rigged of a system and prosecutors control the charging decisions and force you to go to trial or plead guilty to something you didn't do and whipsaw you into stipulating to a factual basis that you know you're lying about, if that is the system and how the system works, then okay, I get it. It's a totally rigged, but you don't get at the end of the day if the jury rejects what you're selling. Then how fair is it that you get to still say, okay, well, you rolled the dice, we lost, and now we're going to punish you for what we couldn't prove?
Yeah.
I think that's just fundamentally unfair.
Yeah. When I listen to this, I got to say, there is a real shot the judges are going to say here, possibly by a majority, that 50 months is just wrong, and that if they say 15 is more appropriate, Diddy walks a free man.
Well, there is a long shot here too. I mean, one of the things, we haven't played a single clip of Alexandra.
I got it right here. The pornography.
Yes.
Okay, so
yes.
let's set this up. So
Set this up,
the
please.
second argument, the one that I just was so intrigued by, is that the freak-offs that were really the core of the prosecution's case, the freak-offs, the defense says, they were constitutionally protected because this was, in effect, amateur porn, and pornography is protected by the First Amendment. Now, that may sound crazy. I'm going to read you, this is one little paragraph from the defense brief, and I think this explains it. Freak-offs and hotel nights were highly choreographed sexual performances involving the use of costumes, role play, and staged lighting, which were filmed so Combs and his girlfriends could watch this amateur pornography later. Pornography production and viewing of this sort is protected by the First Amendment and thus cannot constitutionally be prosecuted. And I started thinking about this, Mark, and I just thought to myself, how different is this, in terms of the Mann Act, what Diddy did, from two OnlyFans creators, one of whom lives in New York and another who lives in Miami. And the guy in New York tells the girl in Miami, fly up here for the weekend and we'll do a collab, because that happens all the time. And they do a collab. And in that case, they're probably going to try to make money. But still, it's the same elements that they're doing porn and one is crossing state lines. But no one has ever batted an eye on OnlyFans that this is being done. And I'm not sure what the distinction is between OnlyFans and what Diddy did.
I will take it one step farther. The uncontroverted testimony, let me give you layer in a couple of facts. Number one, that there was lighting, that this was staged, that the hotel rooms had a certain kind of an atmosphere and things that were done each time so that they could film it, that they, in these so-called freak-offs, you would see either Puff going and adjusting the camera, or you would see one of the participants adjusting the camera. And those were for a reason, because it was to some degree staged as memorabilia. Number two, the number of these tapes. You remember before this trial, everybody was talking about, they thought this was Epstein. They're going to do the search. There's a vault of tapes, of sex tapes. Diddy was doing blackmail. Well, none of that was true. Guess where they found the tapes? Number one, they had
safe.
Cassie. Cassie had them and Jane had them. And so that's who had the tapes. Why did they have the tapes? Because they were going to blackmail Diddy? No, I don't think so. I think a reasonable explanation is they might have been using the tapes for their own personal purposes. And then to your argument, if that's the case, how is this not more harmless and constitutionally protected because you're not putting it out on the internets, onto a YouTube, onto a OnlyFans, onto a Pornhub, onto whatever platform. If that is legal, how is this illegal when you know for a fact people are traveling not just state to state, but internationally to do these things?
Another way of putting it is that if it is constitutionally protected if people are doing it for profit, it should certainly be constitutionally protected if they're not doing it for profit. That's the argument. And
we're both old enough to remember when they said, "Do you want the government in your bedroom?" Do you remember that? It was fighting words 30 years ago.
Fighting words. Oh God, Mark, help me. The case
Greenwald
versus
Connecticut, which was in the 60s, which was the progeny before the Roe and before Dobbs overruled Roe. I was thinking more the 1996, I think it was, U.S. Supreme Court Texas case where there was, remember, the cops, I think, were peering through the bedroom window to see guys engaged in homosexual acts. And it was like, what the hell is going on here? I mean, and by the way, the whole castle doctrine, this idea that your house is your primary castle, so to speak, we fought a revolution against the British over this idea that your home is your castle and that the government just can't do writs of assistance or quarter their soldiers or invade your house.
I got to say, I want to make this clear that in my head, Diddy should have absolutely been prosecuted over the Cassie video. And there's no doubt he should have been prosecuted and they should have thrown the book at him. But they didn't do it. And the statute of limitations ran. And that's a problem. But there's nothing to do about that now. So you got to look at a case on the merits of the case. And what you're left with here are these two violations of giving a guy money to come across state lines and shoot this amateur video that was never meant to see the light of day. And to me, and my sense is that the Court of Appeals didn't necessarily buy this argument, but this argument to me is far more important even than the 15 months because I really see it. And again, I think about the equivalent with OnlyFans, which is huge now. It's so popular. And that people are flying back and forth all the time because some of these creators have huge followings. And if you take two creators with huge followings and you have them collab, you could make a ton of money off of that. And so this happens all the time. And I don't see the difference other than with the OnlyFans case, they're making money, and yet they're protected. So if they're protected, why would somebody not be protected if they're not making money and it's just meant to be private?
You know who I thought of immediately, and just pure serendipity, somebody I know was with his widow yesterday, and I couldn't get to my phone fast enough to FaceTime with her, was Larry Flint. And Larry Flint famously fought these battles in federal court over the pornography battles and the First Amendment and the famous, I don't know, I'll know it when I see it, and that whole litany of U.S. Supreme Court cases. And it's really, They never mentioned the one thing that always bugged me about the case, and with apologies to Judge Sobrahamian, who kind of vaulted two angry men into the stratosphere when he when I was tapped on the shoulder by Agnifilo to come into chambers and told me that it was outrageous that I called the prosecution a six-pack of white women. With all apologies, the idea of prosecuting an iconic black man for whatever you want to say, Diddy is an iconic black man, and you would be blind, deaf, and dumb if you didn't recognize that. And to prosecute him for the Mann Act, which has such a rich history of being used against iconic black men.
It was passed for that. It was passed for that reason. It was racist.
Correct. Yeah. Correct. It was, at one point, remember what it was called? The White Slave Act.
Yeah, the Mann Act was used so that black guys would not date white women or have sex with them.
Correct. And by the way, for those who don't know, it's not M-A-N for man, going after the man.
M-A-N-N.
It's after, M-A-N-N, who was I believe, the senator who it was named after, and who coined it. And it was used against Jack Johnson, who the famous boxer, was used against Chuck Berry. I mean, it's just always used, with rare exceptions, against successful black men. And it's I think that's, to do that in New York City and have the jury go out and try to convict on that, and did convict on that. I think it gives these judges, who understand. I'm going to go back again. If you listen to that argument, we could play clip after clip. It's amazing how familiar they were with the record. And I say that because sometimes one of the great frustrations is to be in front of the Court of Appeals judges who don't engage with you, or don't know the record, or ask questions that seem to betray that they don't know the record. And that's a great source of frustration. That was not the case here. This thing was a masterclass.
Yeah. Okay. So now you don't know this, but we just broke this story. And this is kind of crazy. So, based on what we just said, I think there is a real chance that Diddy is going to be a free man soon. There is a lot of angst in the Holmby Hills neighborhood where Diddy owns a home. And this is one of the homes that was raided when you saw that phalanx of, FBI and DEA, breaking into the house, where you saw just the chaos outside. This is maybe the most exclusive area of Los Angeles, Holmby Hills. And the neighbors are apoplectic right now, we're told, that Diddy might come back. And they are upset by the way, let me just read you. I have to be careful with my phone so you don't see you sending me this stuff. But I'm going to read you some of the people who live in that area. Patrick Whitesill, who was married to Lauren Sanchez, who was, bigwig at William Morris Agency. Alexandra von Furstenberg, Sean Parker, Evan Spiegel and Miranda Kerr, Kylie Jenner, Google's CEO, the former CEO, Eric Schmidt, Ridley Scott, a lot of very famous people in that area. We are told they are really upset that he may come back for a couple of reasons. One, they just don't want tourists swarming the area. Two, they don't want Diddy in the area. And three, they turned out, and I didn't know this until today, they were constantly calling the police because Diddy's sons were throwing these insane parties, and the police were coming there all the time. They do not want him back in that area. And Mark, this is the capper. This is the craziest part. There are realtors in that area who are disclosing to prospective buyers to nearby homes that Diddy owns a home where he does. And they're disclosing it because in California, you have to let prospective buyers know about material facts that could affect the sale and resale of the home. And they're saying that Diddy is so toxic that they feel they have a legal duty to disclose that he lives there to prospective buyers.
I wonder, would that same principle have to be applied to the Intercontinental Hotel? Oh, I forgot. They tore it down and rebuilt it across the street from my office. So I guess they don't have to disclose to the hotel guests. So, by the way, if I had to bet, and I've not talked to Sean about this, but based on the bail filings and some other stuff that I wouldn't want to disclose, I don't think he would be coming back to LA anyway. I think he'd be going straight to Florida. I think that's where the minute he's released. By the way, also, there is the defense asked for his immediate release pending the decision, meaning, hey, judges, if you in your conference, when you discuss the case after oral argument, generally the judges will discuss the case before they go out onto the bench and hear oral argument. They will discuss it afterwards to see if there's been any change. One of the things that was asked was for an immediate release. And the reason for that is precisely what you said. If they were to believe that 50 months was just so over the top, so outside the realm that it couldn't be done under their new bright line rule that I think they're going to do, they could order immediately that he be released on bail. And that could come any day.
So you think there's actually a reasonable chance they would do that even before writing an opinion?
I do, actually. I don't see any reason in the world when he's been in, what isn't he, 2 years,
19
going on 2 years,
19 months.
20, 19 or 20 months, because it was September, right?
He served
2024.
19. Yeah.
Yeah. So if he's arrested, then what? And he's done 19 months, which in effect is 24 months with good time, work time in a halfway house or something like that. If you generally tack all of that on, even if he doesn't do something like an RDAP program or one of the other programs that also cuts the time off, he's done in essence a 30-month sentence already. And if they feel like 50 is too much, why wouldn't you release him on bail right now?
Yeah, I mean, they asked for it, and it seems like they were somewhat receptive about the 50 months. The question is, then what do they think is appropriate? Do they send it back to the trial judge and keep him in jail until the trial judge rules again? I'm not sure how they would do that.
Well, but what would most logically happen is if they were to make a ruling, and then, the prosecution always has the ability, if the ruling went Diddy's way, to go one step higher, which is the U.S. Supreme Court. And by the way, for those who say Diddy's case will never get there, don't be so sure. This is what all three judges said. It's a case of first impression, which is something that the judges would have to talk about. This has been a hotly contested issue in the federal courts about using acquitted conduct. If it needs to be settled, it should be settled.
But there's something here, that if the appeals court rules in Diddy's favor, the prosecution can appeal, but Diddy's out pending the appeal.
Well, that's what it should be. And maybe they feel like, hey, if you're sitting on this court and you've heard
they would
they
would order his release, because if a federal appeals court says 15 months is appropriate, he served more, they would let him out, and then it's up to the prosecution to, go to the Supreme Court, and if they accept it, and the Supreme Court reverses it, then he has to go back into prison. But I think if the appeals court rules, that's law, and I think they have to let him out pending. I can't imagine they would keep him in pending a Supreme Court review.
That would be, I think, the instance you're talking about, if I'm hearing you right. You're talking about after the opinion.
Yeah.
I'm saying before they issue the opinion, they've got the right to just say he could be out on bail right now.
They could.
Grant a bail application.
And then the prosecution would be free to, file for cert with the U.S. Supreme Court, and the Supreme Court could say yes or no. But while the Supreme Court decides what to do, he's free.
Yeah, it's a fascinating legal trial and tribulation.
I am so interested in this pornography argument about First Amendment that I could see the Supreme Court taking it just on that, because it really does have.
I would love to see Clarence Thomas's take on this
and others. Okay, I will see you next week.
See you next week. Thank you, Harvey.